What's going on, everybody? I am Ryan with the Justice for Malykai and Kaleb Hogan Facebook page. If you're familiar, welcome back, or if you're new, thanks for joining us. Today, I know it's been delayed, but we're going to go ahead and dive into the appeal hearing for Kaleb Hogan. Before that, I would like to take a moment and run through who Kaleb Hogan is, as well as establish the timeline of events to provide some context to this appeal hearing that we're going to get into today, just for anyone who may be unfamiliar with the case. So this is right here. This is Kaleb Hogan. If you see me looking to the side, I'm sorry, I got a lot going on my second monitor. I've got a script and I've got my recording software. So anyways, this is Kaleb Hogan. This is his son, Malykai Hogan. He was born in December of 2020, and he unfortunately passed in March of 2021. So he was only 3 months old when he passed. This is a picture of Kaleb from 2021. And down here, this is a Tech 9 concert we went to back in 2016, I believe. We went there together. So anyways, this is Kaleb. Again, if you don't know, now you do. Unfortunately, his son passed away due to homicide in 2021. And obligatory trigger warning. You know, we're going to get into a lot of awful things today, and let me just say, if I sound morbidly casual about this, I assure you that is not the case. We've all, myself and the rest of us who support Kaleb and believe in his innocence, we've had, a good 4 years to sit with this case, so we've moved, well on past the acceptance phase, and I would just like to read the facts as they are. And I feel like, this has been going on long enough. I can do that candidly. So here we go. Here's the timeline. So on March 23rd of 2021, around midnight, Malykai's mother was up with him before getting ready for work at around 5:30 a.m. That morning before Kaleb woke up, she feeds him. And by 7 a.m., handed him off to Kaleb before she left with Kaleb's mom, named Amber. Amber and Malykai's mother worked together at the same office, so she was picking her up to take her to work. That morning, Malykai's mother actually told Amber that Malykai had vomited on her. Excuse me. Throughout the day that Kaleb was alone with Malykai, Malykai slept somewhere around 3 times and ate less than half of his usual bottle. He napped from about 7:30 to 10 a.m., and then maybe 11 a.m. to 12:30 p.m., and then 1:15 p.m. to around 2:30 p.m. At 2:30 p.m., Malykai woke up, and he was fussy, so Kaleb laid him on their bed to make a bottle. The first bottle came out too hot, so Kaleb went back to make another. And when he returned, he unfortunately finds poor Malykai choking on his own vomit. Kaleb tries to pat his back and clear the airway with his finger, but nothing was working. And at this point, unfortunately, Malykai has stopped breathing. Kaleb frantically makes a call to 911 at about 2:40 p.m. And the 911 dispatcher instructed him to perform CPR while he remained on the phone with the dispatcher. This happened for about 10 minutes until EMS arrived somewhere around 2:50 p.m. And they went ahead and took over and separated Kaleb from Malykai while police questioned Kaleb about the incident, and they just ran down through some of the the normal stuff, the emergency contact, what was happening when he went down, et cetera, et cetera. And while they were talking to him in the apartment as EMS worked on him in the other room, I don't think the police were suspecting child abuse. All anyone knew at that point was that the child had stopped breathing. Let's see, where was I? Around 3:30 p.m., Amber and Malykai's mother arrived back at the apartment as they had received a phone call from police saying that there was an emergency and they needed to get down there. Sorry, I keep losing my place here. So they get there at 3:30 p.m. and officers were searching the apartment, taking photos, so on and so forth. After that, Malykai is taken to Wesley Medical Center via ambulance, and Kaleb, Malykai's mother, and Amber went to Wesley Medical, where Malykai was put on life support. Doctors found high blood sugar, and during the x-ray, discovered new and old rib fractures that were healing. And this is what triggered the child abuse investigation by the child abuse care specialist that was working there at the time. Her name is Dr. Weeks, and we're going to get a lot into Dr. Weeks today. She's going to come up a few times. Excuse me. I'm sorry. While they were working on him, she also identifies an old healing brain bleed from about a month ago. Excuse me one second. Let me go ahead and silence this while I find my place again. They find a old healing brain bleed, so internal bleeding from about a month ago, and a new ongoing brain bleed. She went ahead and reported to the police that Malykai had most likely received these injuries from a shaking. That was her diagnosis, was shaken baby syndrome. That evening, police interview both parents. The mother is not read her rights. She denies any involvement, and she swears that Kaleb could never do this. While Kaleb was Mirandized, was being accused as the perpetrator, and he denies causing any harm and denies that the mother could have done this. So we have both parents saying, I didn't do it. I don't think the other person could do it. Both of them during this first police interview end up mentioning a prior incident about a child carrier harness, where Kaleb and Kaleb's mother, Amber, noticed one day bruising on Malykai's ribs. So they took him to Malykai's PCP, his primary care provider, and the doctor chalked it up to a defective baby carrier / harness. And all she did was instruct them to get a new one, obviously not knowing that the bruising was due to child abuse. No one knew at the time, except the perpetrator. So the police asked Kaleb during that first interview if he thinks of anything to come back, and then the next day on March 24th, he voluntarily goes in for a second interview. I think both of the parents went in for a second interview. Kaleb did agree during the second or before the second interview to take a lie detector test, but I think maybe they ended up not administering it, and we'll get into that later. So Kaleb goes to the officers and tells them, I've been up all night racking my brain, trying to figure out what could have happened to Malykai. And he says that a few weeks ago, he had been up all night with Malykai, and he wasn't going to sleep. Kaleb got frustrated, and this is about the motion that he made to police. He had his hands out like this, said he had the baby out in front of him, and he said something to the effect of, why won't you go to sleep, stop crying, etc., etc. So he admits to gently shaking Malykai around 6 weeks earlier, and then he also tells police that he shook him that previous morning after he had stopped breathing in an attempt to wake him up, because the CPR wasn't working. His body was lifeless. He wasn't moving. And then that day, so one day after Malykai goes down, Kaleb is arrested for child abuse, because at this point in the story, Malykai has not passed away yet. So they arrest him for child abuse, and the investigators are essentially arguing that Kaleb made a minimized confession, that he, told like a half-truth to try to minimize his culpability. So the mother ends up not doing a second interview because the police had got their quote-unquote confession, and she returns to the hospital with her parents, so not Kaleb's parents. On March 25th, Kaleb was in jail, and I believe pretty much only Malykai's mother could visit due to the open case that was going on. No one else could come visit, so not Malykai's grandparents on Kaleb's side. And then the next day, on March 26th, 2021, a test that the doctors were running confirms that Malykai was brain dead. The mother did agree to end life support, and Malykai unfortunately passed away on March 26th of 2021. The same day, Kaleb and the mother were pulled into a court hearing to go over Malykai's organ donor status, where Kaleb did consent to organ donation. And then his death is ruled a homicide by police, but later the autopsy actually ends up showing that the cause of death was blunt force trauma, not shaken baby syndrome. And they actually, even though the manner of death was different at this point, they never did reopen the investigation because they had gotten their confession. So Kaleb was now charged with child abuse and murder now, unfortunately, first-degree murder. So this case, they have pretrial hearings and evidentiary hearings. This is right smack in the middle of COVID at the time. Remember, we're in March 2021, so we've barely even lived with COVID for a year at this point. The case ends up getting dragged out and stalled for about 2 years until January of 2023. Kaleb also did make bail during this time, so his trial did not take precedence versus people who are actually sitting in jail, because people who are in jail have a right to a speedy trial. So in January 2023, the Kaleb Hogan trial finally took place. He faced felony murder and child abuse charges in the death of his 3-month-old son. The prosecution built its case around Kaleb's admission to police that he gently shook Malykai twice. Once 6 weeks earlier because of this motion that he made. And then once on March 23rd, the morning of the emergency, after he was not responding to CPR. They argued that since Kaleb was alone with Malykai during the critical hours before his 911 call, pointing to medical evidence of brain bleeding, retinal hemorrhages, and rib fractures. Carrie Weeks, the doctor that was working on Malykai the day he went to the hospital, she testified that these injuries, including the older healing fractures, indicated abuse, likely from squeezing or shaking, and that the acute injuries, or the injuries that happened the day of that eventually caused Malykai to go down, she testified that they had happened moments to hours before Malykai became unresponsive. But she is just the on-site doctor. She is not the autopsist. And the state used these prior injuries to suggest Kaleb didn't act by accident. They used the prior injuries to Malykai to show that he had already committed a crime once, and then they used his confession to charge him with the March 23rd injuries that eventually caused his death, Malykai's death. Kaleb's defense pushed back and argued that the prior injuries were not proven to be his fault, and they weren't proven to be his fault, and that multiple caregivers had access to Malykai in not only the hours before his death, but the weeks before his death. They end up calling Dr. Lyle Nordhook, a forensic pathologist who independently reviewed the autopsy and testified that the fatal injuries could have happened up to 12 to 24 hours earlier, potentially implicating Malykai's mother, who was with him before Kaleb. Kaleb's defense tried to exclude these prior injuries because they were arguing that since they weren't proven, then they shouldn't be used as evidence. But the judge ends up allowing them anyways and instructed the jury to consider them only for absence of mistake, which means they were only allowed to consider them as to if Kaleb acted knowingly. So they were told to consider them only for absence of mistake or accident and for Kaleb's credibility, not for guilt on the charges. The jury convicted Kaleb of both felony murder and child abuse, and he was sentenced to life in prison, not eligible for parole for 25 years. His motion for a new trial, arguing errors in admitting the prior injuries, was denied, which set the stage for his appeal to the Kansas Supreme Court. And also in his motion for a new trial, he also argued that his defense counsel was ineffective. Okay, so now here we are today. Today is the 17th of August, 2025. 16 days ago at this point, on August 1st, 2025, the Kansas Supreme Court overturned Kaleb Hogan's 2023 convictions for felony murder and child abuse in the tragic death of his 3-month-old son, Malykai. What this means is that the court threw out the guilty verdicts because of serious errors in the trial. The court also vacated his sentences, which wiped out his life imprisonment term, and sent the case back to Butler County District Court for a possible retrial. At the time of this reading, we still don't know what's happening with that retrial. The Supreme Court ends up finding a major mistake in how the trial handled evidence. The prosecution introduced prior injuries to Malykai, like healing rib fractures, to suggest Kaleb didn't harm his son by accident, but the state did not prove Kaleb caused those earlier injuries, as multiple caregivers had access to the baby. Kansas law, specifically KSA 6455, which is what we're going to get into today, bans using past acts to paint someone as likely to commit a crime or propensive to commit a crime. We'll get into that too. Excuse me. And that is what happened here. The trial judge didn't properly check if this evidence was more harmful than helpful, risking the jury's view of Kaleb's credibility and guilt. Even a jury instruction limiting how they could use this evidence did not fix the problem. With the case relying heavily on Kaleb's admission of gently shaking the baby, the court found a real chance this improper evidence actually swayed the verdict. So the convictions were reversed, the sentences vacated, and the case sent back with a warning to either exclude those prior injuries or prove their relevance properly next time. This ruling drives home the need for strict evidence and rules to ensure a fair trial. And that's what we're going to get into today. So here we go. And if you are watching this in the multi-part series, then you can just go ahead and click forward over to episode 2, where we get into Kaleb's appeal lawyer. If you're just watching it in the full VOD, then just keep watching along and we'll get right into it. Okay, so here we go. This is the testimony of Michelle Davis, or not testimony, the argument from Michelle Davis in front of the Kansas Supreme Court. Myself and Kaleb's family and his friends all went to this hearing. So there are probably a couple stages in the video where you can see us in the background. There is 1 or 2 minutes of intro here, but we're just going to go right into it, and we're going to start breaking this down as we go along. Excuse me. Again, I'm sorry if there are any imbalances between my voice and the audio. I have done my best to line them out, but once again, I'm learning as I go here, so please be patient with me, and we're going to try and just jump right into this. So without further ado, after I get done moving my mic here we go.
With that, I will call 126442, State of Kansas versus Kaleb Paul Ron Hogan. As counsel take the bench or their seats, I will tell you that, like the students, the court has read the briefs and studied the record and have made notes about the cases. So we may be referring to those notes on our computers or on paper as we go through the argument. Please know that as we do that, it is part of our process of helping.
And if you're watching the subtitles right here, keep in mind that the court reporter was transcribing this as they spoke. So there's a 5 to 10 second delay on the captions. But if you're on YouTube, you should just be able to go ahead and pull up the auto captions if you so desire.
Us assess the arguments of the counsel, and we are actively listening to them as they do so. So with that, Ms. Davis, you may approach the lectern.
I'm Michelle Davis, and I'm appearing on behalf of Kaleb Hogan, and I'm requesting 3 minutes for rebuttal, please.
3 minutes is granted.
The state convicted Mr. Hogan of child abuse and felony murder based on events that took place in March of 2021, I believe. Mr. Hogan called the police, 3-month-old baby. It's afternoon. Child had slept most of the day. He found the child having trouble spitting up a little bit, vomiting, trouble breathing, and then the child went limp. And he called 911, and the child was taken to the hospital. Did not recover. The police interviewed the parents that night, the father and the mother, and each of them denied that they had harmed the child or that the other would do so. There was also some family of the parents that had contact with the child, and then the child was with a caregiver every Thursday and Friday of every week. Other than that, the parents pretty much shared or divided caregiving responsibilities. The next day, the police called the parents back in, only talked to Kaleb, and he was obviously not well, tired, distraught. He gave some statements during that interview that the police then arrested him for and claimed that he had confessed to the crimes. And they relayed that information to the pediatrician, the child abuse pediatrician that testified for the state at the hospital. So she prepared a report that said that law enforcement said that father had admitted to shaking.
And keep in mind that the person she is talking about here is Dr. Weeks, the child abuse care specialist at Wesley Medical Center.
The child, and that those kind of injuries could cause the rib fractures that had been identified at the hospital. There were some healing rib fractures on the child. And what Kaleb had demonstrated was, a gentle shaking where he was holding the child in front of him. And it was that this had been done 6 weeks prior, where he was frustrated and was telling the child, go to sleep, I'm tired, kind of holding the child in front of him. And then after this event happened, where he couldn't get the child to respond, he had done the same thing, holding the child, trying to get the child to wake up. So
let me interrupt, because this is what's bothered me when I was looking at this last week. Is your contention that the prosecution misrepresented to the jury what the video showed? You seem to be talking about, well, it wasn't the shaking that he demonstrated wasn't much.
Right,
Wasn't
because
very
the video is
bad.
there. We could observe it, right? And that was, I watched the video, so and
Right,
then
but is it
also,
your contention that the state misrepresented what was on the video?
I'm going to give you a long answer if that's okay. Basically, this started with there's a captain with the police department who basically said,
The person she's referring to is Captain Ralph. He was the captain of the Augusta Police Department at the time in 2021, he is now retired.
You know, he confessed, he admitted to doing this. And so it's when you say the prosecution,
Well, I thought I said the state.
Okay, if you say
know,
the
maybe
state.
the second time I said the state. I just,
Yes, and law enforcement, this started with law enforcement, and they decided he had done it. In fact, you could tell when they interviewed the mom that this captain believed that the dad had done it, because he kept trying to get the mom to say the dad had done it and didn't really confront her about whether she had done it. I mean, that's my opinion, but I watched the videos. So
I'm
I think,
trying to figure out what to do with this, because in the end, the video is played to the jury and they get to see it, and they convicted. I don't know how I guess I'm trying to figure out what's the legal support for us to look at the video and say, oh, it's not as bad as the state represent. See what I'm asking?
yeah, but that's not the issue here.
Okay, that's what I'm
Okay,
getting
so
at.
this case goes to a preliminary hearing in December, and that preliminary hearing. So the law enforcement comes out of the interview and they say he confessed, right? They put that in their affidavit that he had admitted to shaking the child, but they didn't explain what type of shaking he described, right? But at the preliminary hearing, Captain Ralph testifies. This was a gentle shaking. Those were his words. So Captain Ralph at the preliminary says he admitted twice to being a gentle shaking. But then Weeks, the child abuse pediatrician, also testifies at the preliminary hearing. She says this was a violent, forceful shaking to cause these injuries. So right there in front of the prosecution and the judge is the contrast. Then the autopsy, the state's autopsy expert says this was a blunt force injury. This was not even a shaking. Shaking could have been involved. But this child was struck on an object, or an object was struck on the child.
So here is my first issue with this. Again, you recall from the timeline that we went through, Dr. Weeks, again, she tells police that Malykai was suffering from a shaking. And then after Malykai has passed and they do his autopsy, it's ruled blunt force trauma. And I don't mean to be gross, but again, what she says here is that either a blunt object was used to strike Malakai's head, or his head was used to strike a blunt object. And so keep in mind, these injuries go back weeks to months. So right there, we're already going from possibly a frustrated parent who's lost control for a moment to a disgusting act of abuse that it's just so, to me, so far outside shaking the baby. Not that shaking the baby is okay, obviously, but we're not talking about a moment of lost control here. We're talking about a deliberate, violent, disgusting act. And again, I don't mean to be gross, but I just want everybody to understand the seriousness of this. So let's go ahead and keep going.
So the evidence is there. Then the motion hearing comes up 4 weeks later, or 4 months later, 3 to 4 months later, where the defense is trying to prevent. What they're trying to prevent is not the videotape. They're trying to prevent the evidence of prior injuries to the child from being admitted because it's so prejudicial.
What she's saying there, when she says the videotape is the police interview between the police and Kaleb. And so keep in mind, Kaleb has always maintained his innocence here, and he was not trying to hide what he told police. His defense was trying to hide, or not even hide, but just leave them out of the trial, the prior injuries. And if that sounds weird, yeah, it's strange, obviously, but we're going to get into why they wanted to hide the injuries.
Prejudicial, because the state had no proof that Kaleb had caused these injuries. And so simply putting in older injuries to this child without unknown perpetrator had no probative value, of material fact in dispute, and was highly prejudicial. The judge at that hearing says the state's going to present evidence showing a causation between the defendant and the injuries. This is a proffer hearing. It's not an evidentiary hearing. The prosecutor doesn't get up and say, that's wrong, judge. Actually, we don't have that evidence. We can't do that.
Real quick, let me Okay, I'm still recording. So I want to get into what a proffer hearing is, just so you kind of understand what's going on here, because before all this, I didn't understand what a proffer hearing is. So if you look over on the right side of the screen, I've got all these definitions listed out here, and yeah, I know it looks like a doozy. It's a bunch of colors, but we're going to get into it. But for just right now, a proffer hearing is a legal proceeding where an attorney formally presents to the court what specific evidence or testimony would have been introduced if it were allowed without actually presenting the evidence itself. This is often done to establish a record for appeal, where we're at right now, to seek a ruling on admissibility or to clarify the relevance of evidence for the court's consideration. Relevance is a key word here. And then she says this is a proffer hearing, not an evidentiary hearing, and this is after the preliminary hearing. And a preliminary hearing is a pretrial hearing where the prosecution presents evidence to show that there's probable cause to believe the defendant committed the crime, allowing the case to proceed to trial. So and we all know what probable cause is, right? You don't get a search warrant without probable cause, right? You can't smell any weed in the car, da-da-da-da-da. And then an evidentiary hearing is a court proceeding where evidence is presented to a judge to resolve specific factual or legal issues, often to determine the admissibility of evidence or to settle disputes before the trial. But remember, we're not in prelim here, we're in evidentiary hearing. What she's talking about is a proffer hearing, okay? So let us keep going.
You heard the preliminary hearing 4 months ago, right?
Was there circumstantial evidence, though, to support that sort of theory in the fact that there was sort of this timeline established where for the prior injuries, some of the interview from the defendant where there was an acknowledgement of prior, albeit gentle, shaking, and therefore, it's sort of a why isn't this just a credibility issue? I guess two questions. Why wasn't that enough for the jury, if it so chose, to make that inference that as to the identity of the who caused the prior injuries? And second, was it also based on that same evidence simply a credibility issue, whether the jury was going to believe Mr. Hogan or not, that made that evidence potentially relevant?
Just at the start of this second video, he's going in there going, you're telling me I did this. I must have done this. I can't think how this could have taken place. Maybe this gentle shaking I did it. He didn't use the word gentle, but he's trying to explain. He's trying to work with them. Then when the captain says, no, what you're describing to me couldn't cause these injuries. You must have done something more. And at the end of the video, he's going, no, I didn't do anything more. There's no credibility here. Take his statements for what they are. He denies seriously harming the child. And with the defense here, they don't have a problem. If you want to say, if he was inconsistent about the first interview, he said he didn't shake the child. The second interview, he said he did. On the day in question, that's fine. You can bring in everything that happened around the events.
I just want to take note of this. She says, it would be okay for them to take issue if he was inconsistent between his first interview and his second interview. Full disclaimer here, I saw the police interviews, but I do not have them because this is an active case, right? So I can't just obtain the evidence. Off of memory, I cannot remember that he did not say in his first interview adamantly, I never shook him. All he was really saying was, I did not hurt him. So just keep that in mind.
Of what took place, right? And he denies that he did this. He denies that he previously harmed the child. If you watch that interview,
can you connect the dots for me between your argument about the interview and the judge's evidentiary ruling that's actually in front of us?
That's actually,
I take it what we're talking about here is the issue of the court's denial of defense's motion to exclude evidence of prior injury, right?
Right, because...
So I'm asking you you're spending most of your time talking about the interview.
Right.
I just want you to connect the dots for me.
Right, because there's no evidence. You've got you've got healing rib fractures, perpetrator unknown, right? The defense is saying, we're not disputing this child was injured. That's not a material fact in dispute, right?
So what is
So-
the legal argument as to why the evidence should be excluded?
Because 6455,
Okay,
because they're using this evidence. This wasn't just the evidence.
Okay, let's get into 6455 here. We're going to be hearing this a lot, and I want to make sure that everybody understands what they're talking about because they just glaze over it, right? So at these hearings, they're assuming if you're in this room, you know what all of this means. I didn't know what any of this meant when I was in this room. So KSA 60-455 governs the admissibility of evidence of prior crimes or civil wrongs in Kansas courts. It prohibits using such evidence to prove a person's disposition or propensity to commit a crime or wrong to infer they committed another act, except when relevant to prove specific factors like motive, intent, or identity. In SA cases, prior acts of sexual misconduct are admissible if relevant and probative. We are going to get into the definition of probative later with specific procedural requirements. The statute also defines act or offense of that word misconduct exhaustively and allows evidence under other rules if applicable. But we are not talking about the SEX word today. This is just part of the definition. So again, 6455, anytime you hear them mentioning this, we're talking about a statute that prohibits using prior crimes or civil wrongs to prove a person's propensity to commit a crime or wrong to infer they committed another act, unless it's relevant enough to prove specific factors like motive, intent, or identity. Why does this statute exist? We are going to find out why, but let me shut up and you can hear it from her.
As it came in, it was the detective saying, or it was Captain Ralph saying, you know, he did it.
yeah,
He did it. It was the judge's limiting instruction saying he did it, right? So it's not just evidence of the prior injuries, it's they're pointing the finger at Kaleb saying he did this, right? That's 6455 evidence.
right, you're saying it was brought in for propensity, not for the purported reason that the court gave.
Right, because those things weren't in dispute. The defense wasn't disputing the child was injured, right? Let's see, the judge's reasons were that he didn't say, I dropped the child, and that's how the child was injured, right? He's not claiming accident. He's saying,
If any of you watching have ever watched any of my previous videos on this topic, you might remember when I said he never said that he dropped the child. So, right, remember, they're accusing him of admitting to shaking the child, which ultimately caused his death. But shaking the child is not what ultimately caused his death. So let's assume for a moment that Kaleb is guilty and that he was trying to give some sort of half-truth. Don't you think it would follow that if he did it, he knew probably that Malykai's head had been hit somehow? Why would he not say that he dropped him, right? So I just thought that was interesting that, you know, a year and a half ago, I was already talking about this, and then the appeal lawyer comes up with it. So anyways, sorry.
I didn't do this, right? So his state of mind and whether it was an accident, the reasons given are just not in dispute.
I thought the judge's ruling was that it went to the credibility about whether or not the shakings were gentle or at not, you know, as he demonstrated,
Uh-huh.
and also as to the credibility that the last shaking occurred after the baby had been non-responsive and as opposed to having occurred before.
Mhm.
So why is that not
So what
go to
you-
the credibility of
Right.
those,
What you're
that
call-
timeline?
What you're
basically?
calling credibility is really just saying, is he minimizing? It's just Captain Ralph's theory. I mean, all this is just Captain Ralph's theory just getting pushed down the road.
But
Is
why
he's
doesn't the
minimizing.
jury-
The theory is he's minimizing, right? He's
So again, this whole case is essentially resting on Captain Ralph's theory that Kaleb was minimizing his confession. And if that minimized confession, for sake of argument, we'll call it, was not made, then it goes to follow that they would have had to consider both parents in this. But as soon as they got their confession, they did not consider anybody else. They didn't consider it was possible whatsoever. I'm not saying that to place blame on anybody, but I do want that to be known, that I think it's relevant that in 2 interviews they had their suspect, and then the autopsy shows a different manner of death, and they never reopened the case. Nothing. This is all just resting on a theory that Kaleb is minimizing his confession. He's excusing himself from his culpability.
Saying he gently shook the child, but he's minimizing. And so when the judge is calling credibility, is really saying, are you going to believe the state that's saying he's minimizing or not? And so it's really propensity evidence, because it's saying he's not minimizing because look at the damage that was previously done to this child.
Well, we have case law that says with propensity evidence under 6455, even though credibility is not listed in that statute, credibility can be a factor that allows prior acts to come in. So why, that's why I'm trying to get to,
I'm going to give
why not here?
2 reasons here, right?
Okay, so let's get into propensity. And if you're looking at the screen right now, you can see all the different colors I have highlighted here. And so what we're going to find is that as we continue to run through these legal definitions that you're going to hear a ton of in this hearing, what we're going to realize is that these kind of every word references another word. And I'm not trying to make light of this situation, but it really is amazing just how the devil really is in the details here. So I'm not really going to, try to make you follow along with the highlighted words. But like I said, as we go through here, you're going to see how one word is referencing every other word, right? At the risk of sounding like a tinfoil hat wearer, everything here is connected, right? So propensity, right? They're talking about propensity right here. They're talking about credibility. Propensity in the context of KSA 60-455, propensity refers to a person's inclination or tendency to engage in a certain behavior. So if I'm an impulse buyer, then I have a propensity to make rash, quick decisions to buy things at random, right? In this context, though, we're talking about criminal or wrongful acts based on evidence of their prior conduct. That is important. This statute generally prohibits using prior crimes or civil wrongs to demonstrate a person's propensity to commit a crime, as this could unfairly suggest they are likely to have committed the act in question due to their character or past behavior, except under specific exceptions like proving motive, intent, or identity. So we're going to hear propensity a lot. We're going to hear KSA 6455 a lot. And real quick, let's get into credibility. Let me get a drink here. Excuse me. In Kansas law, credibility refers to how believable or trustworthy a witness or defendant's testimony is, as judged by the jury or fact finder. It's assessed based on factors like the consistency of their statements, their demeanor on the stand, any corroborating evidence, and their character or past behavior. It must be relevant and follow evidentiary rules. Juries are typically instructed to weigh credibility based on evidence presented, not assumptions or bias.
This is evidence he committed a crime, right? That's not evidence. The state had no evidence that he committed the prior injuries. All we have is.
So again, if you're not following along here, she's saying the state had no evidence to prove that he committed the prior injuries, right? We have a whole time, excluding the March 23rd, we have a whole timeline here, weeks and weeks and weeks of past abuse that we know happened but it was never proven who did it. And so since we don't know who did it, 6455 is supposed to protect his it's supposed to protect the injuries against his statements, essentially, right? So if we don't know who did it, if we don't know that Kaleb did the injuries, we can't argue that he's propensive to harming children, but if the jury is still allowed to see those, this can undermine his credibility. Sorry.
Evidence of a gentle shaking and then denying that he caused the prior injuries. No, I didn't do anything that would have caused these significant injuries. At the time, he doesn't even know the extent of the injuries, right? This is the day after it happened. He doesn't have all the autopsy photos and all that. He's just saying, you're telling me my child's hurt badly and I didn't do this, right?
I'm sorry, I can't recall which doctor, either the pathologist or the Dr. Wells, say that
Dr. Weeks, not Dr. Wells. Remember, Dr. Weeks was the child abuse care specialist that worked on Malykai the day he went down.
holding the baby as described could result in fractured ribs?
As what law enforcement had relayed. Law enforcement says dad admits to shaking the child and holding the child and shaking the child, right? But they didn't say the gentle shaking part, that this was very just kind of waving the child in front of me, right? So she's making her conclusion based on what Captain Ralph is saying.
She's making her conclusion based on what Captain Ralph is saying. Let's remember this. I'm trying not to be annoying, but I want to make sure everyone's following along. Dr. Weeks tells the police Malykai's injuries are sustained from a shaking. The police question the parents who shook him. The police get there, for sake of argument, minimize confession out of Kaleb. So the police tell Dr. Weeks Kaleb admitted to shaking the child. But they never did tell her that all he said was that it was gently. They just told her that he shook the child. And she testified to this in court later on during the trial. Well, even before the trial, but also during the trial in 2023.
Telling, right? As did, it just kind of filtered through the case. He did not admit, and
Sorry, I wanted to make sure my recording was good.
The type of shaking that he described would not have caused injuries to this child. She acknowledged that, right? She never saw the video. She didn't know. She was just going off of what she was told. And they're proclaiming.
She never saw the confession. She was just going off what she was told.
A confession here. So she's assuming this is the violent, forceful type of shaking that she said would be necessary at the preliminary hearing. And then the other part about why it's not admissible, you said this in Prine. The state can't open the door to 6455 evidence. The state.
And I'm sorry to keep pausing this here. What she said, I thought she said you said this in pride. Like prideful, but no, what she's talking about is State versus Prine, which was another Kansas appeals case. And I'm not going to stop the whole video and get into that right now. But if you stick around to the end, we will get into these other Kansas versus whomever cases that are mentioned during this hearing and show how they are related to the case of Kaleb Hogan.
It can't, the defense has to open the door by its defense at trial or something that's said at trial. The state admitted the video, the prior statements. The state can't do that and then say, we're putting in his statements. And so now his credibility is an issue. So we get to bring in 6455 evidence. I mean, if you did that in every case where the state was putting on the defense prior statements, they could always say credibility is an issue, right? We've got some.
What she's saying here is the state can't bring in 6455 on evidence from every defendant. Otherwise, they could use that to attack every defendant's credibility. We'll get more into this later, but anyways, let's just continue.
Something different at trial than what he said before, so we can bring in 6455 evidence. No, the defense has to open the door to 6455
I'm wondering,
evidence.
if, as I described earlier, I was having trouble connecting the dots between
Uh-huh.
the interview and the actual evidence. And I'm
Mhm.
wondering if the disconnect is this even 6455 evidence? I mean, is it a prior bad act? It's just a evidence of a prior injury.
Right, but the problem is you've got the captain telling everybody he's confessed.
Well, but that evidence gets tested in the adversarial process of the trial. And as you pointed out, the defense apparently was able to pretty firmly refute that.
No, I don't think so, because he was convicted.
Well, I don't think you can reason backwards from that. The jury obviously didn't believe your client.
Well, I
But
don't
my
know-
question
Or
really,
they were prejudiced by all of the evidence of prior injuries to the baby. I mean,
well, but the question is whether or not that evidence is admissible, right?
you can't have it both ways. You can't say this is not evidence of a prior crime when the state is saying it is evidence of a prior crime and telling the jury it's evidence of a prior crime through their witnesses and through a jury instruction. When everybody's telling the jury it's that, you can't say it's not that. If it's not that, then you admit the evidence of the injuries, you give a limiting instruction saying evidence of injuries to this child has been admitted. There's no evidence that the defendant caused these injuries. But then the jury saying, well, why are you admitting the evidence then? How is it relevant? And you know what? If I'm on the jury and I've got a judge telling me to consider this evidence.
Again, so the state never told the jury that it's unproven who did the prior injuries. And remember, in this context, the prior injuries are the healing rib fractures and the healing brain bleed, and then the new injuries are what they call the acute injuries. And in this hearing, when they're referring to 6 weeks ago injuries, they're talking about the prior healing injuries that Michelle Davis here is arguing were never properly admitted. And if they talk about acute injuries, the acute injuries are what ultimately led to Malykai's unfortunate death.
For accident, lack of mistake, credibility, I'm thinking this guy did those prior injuries because why else would the judge be telling us to consider it? And you know what? They're right. There's supposed to be a court finding. Before you admit that evidence, a judge has to find that it's relevant. In order to be relevant, he had to have committed those injuries.
He tells them you can't consider the older injuries to support the conviction of either child abuse or felony murder charge, but you may consider. So he distinguishes that. Is it as strong as what you're suggesting in terms of a directive to the jury?
You meant the limiting instruction, but you may consider.
So the judge instructed the jury that they may consider the prior injuries only to find Kaleb Hogan guilty of child abuse, not murder.
For that's a mistake. Is it? That's what you're referring to, right? So what's he telling the jury to consider it for then?
So what's the?
He's telling him to consider it for whether Kaleb acted knowingly, and if he was credible. I mean, so basically, what the judge is saying is.
Why is the jury supposed to consider the prior injuries that are unproven as to who did it to decide whether or not Kaleb acted knowingly or accidentally? I hope I'm explaining this clearly enough that you're starting to follow along now. If we don't know who caused the prior injuries, how can anyone consider, based on those prior injuries, if he acted knowingly or accidentally? How do the unproven prior injuries help someone discern knowing you hurt somebody versus accidentally hurting somebody? I don't mean to repeat myself too much, but I just want to make sure everyone's following along here.
You know, there's been some, what I'm thinking is there's been some finding here that where the judge found that Kaleb had committed the prior injuries, because why else would the judge be telling us to consider it? I mean, you know, if we're to consider prior injuries in determining whether Kaleb acted knowingly, he must have done the prior injuries, right? I mean,
My point is, he's not really telling them to consider it. He's telling them they may consider it. Is there a
Right.
difference there?
But why would you be telling us that unless you're saying it's probative? I mean, it's probative.
And I hate to keep pausing, but let's get into probative. This is another big one you're going to hear a lot of. In Kansas law, probative refers to evidence that tends to prove or disprove a fact or issue relevant to the case. Something has probative value if it logically supports or undermines a material claim, such as establishing motive or intent or identity, and is admissible unless its prejudicial effect outweighs its relevance, as determined by the court. So essentially, and I have right here in bold letters, to probe. I don't know if this is the correct way to look at it, but in my head, they're using the prior injuries as if they are probative. They're using those prior injuries as evidence to probe his confession that's on videotape. Oh.
I mean, what else? It's probative of to say whether he's done knowingly. That's not his defense. I mean, he's not saying
Sorry, having some technical difficulties here.
I did this, but it was, an accident. He's saying I didn't do this, right? So this limiting instruction is just worthless because the jury either decides he did it or he didn't. There's no innocence here. There's no innocence defense. I think I'm out of time. I'll save my remaining comments for rebuttal.
All right, thank you, Ms. Davis.
Okay, so if you are watching this in several parts, this will probably be part 3. This is the point where District Attorney Darren C. Devaney enters to make his counter arguments to the Kansas Supreme Court. If you are just watching this as the full VOD, feel free to follow along, and let's go ahead and get into it. And before we do that, there's something I want to establish here. I have seen a couple people online try to say that Kaleb's overturned conviction is just a technicality. And I am not going to argue one way or the other. I'm going to do my best to remain impartial. As you remember from the beginning, yes, I personally believe that Kaleb is innocent, but my opinion is not enough to change anything about this case, nor should it be. But I want you to pay attention to this guy. I want you to fully appreciate the fact that he is a public official who essentially holds people's lives in his hands, all on taxpayer dollars. So just I want to make sure everyone is thinking critically here. I do not think that this is a technicality, but I want you to decide, right? Based on what this guy is saying, based on everything you've heard so far, by the end of this video, I want you to come to the conclusion. Is this a technicality, or is this case inherently flawed from the jump?
Morning, may it please the court. Darren Devaney on behalf of the state of Kansas. There's, I guess, the legal issues of 455 or the admissibility of this evidence, and then there were the facts of the case. I was anticipating, I guess, the analysis of one thing that's already been touched on, which was this evidence actually 6455? Because it's kind of, in a way, it's a little bit of a split order that we had in the pretrial motion in limine. And I want to make sure that this time frame is very clear with the court. There was a preliminary hearing that occurred back in December of 21. Some months later, the trial counsel for defense filed a motion in limine with the court, putting this issue at hand.
And if you don't know what a motion in limine is, like I sure didn't, I've got it right here. A motion in limine is a pre-trial motion filed by a party in a legal case requesting that the court prohibit the opposing side from presenting specific evidence or maintaining certain matters during the trial. So this is the point where Kaleb's defense tries to exclude the prior injuries. The goal is to prevent prejudicial, irrelevant, or inadmissible evidence, such as under the KSA 6455 in Kansas, which governs prior bad acts from being introduced to the jury, which could unfairly influence the outcome. And I know what you're thinking by now, if you've been following along so far, because it's exactly what I was thinking by the time I was sitting in this trial. When I was sitting in this trial, watching my friend be picked apart and cross-examined by defense and prosecution, the only thing I could think of was, why would you try to hide the previous injuries? Isn't that one of your strongest defenses in this case? Because if you can't prove that the old injuries were Kaleb, wouldn't you want to hammer that home to the jury? I mean, that's what I would want to do. But, we've gone through some of these definitions before, and I can see why Kaleb's defense did try to exclude these prior injuries, not just because of the fact that they obviously have the potential to poison the jury, but he had a legal reason to do so. I mean, these are the statutes which govern our criminal trials. So, yes, I did think back then that excluding the prior injuries was strange. And on that note, I would think that the jury probably thought it was strange that they tried to exclude these prior injuries. Remember, the jury, if I remember right, they were there a couple times when the defense objected to the admission of a few certain pieces of evidence. And so they were sent out of the room once or twice after the objection was made, so that the defense lawyer could explain on what basis they wanted to exclude the prior acts. And I think he also excluded or motioned to exclude the autopsy because the autopsy had the old healing injuries in there. But he was making that motion based on 6455. And of course, they didn't see on what grounds they were trying to exclude the prior injuries, but they did see, if I remember right, they did see that they were trying to exclude the prior injuries. So I think maybe even that alone could have made the jury think, well, why are you trying to hide something about this 3-month-old child? And the DA here is going to get into that.
The state didn't file a 6455 motion. The state hadn't considered whether or not a 6455 needed to be filed at the time. It was trial counsel for defense that initiated this and kind of opened the, I'll say not necessarily opened the door, but opened the argument up in front of the trial court.
What was your theory on the prior crimes if it wasn't 6455? I think I follow you, but what was it like?
Well,
Grace Gesti? What are we talking?
I was looking, my attention was focused on the autopsy itself. And let's get away from the defendant's statements for just a moment if we could. But the autopsy, we had an autopsy performed. It showed healing rib fractures on an infant child. Those healing fractures and blood on the brain, so these types of things from the pathologist occurred 4 to 6 weeks prior to. And to ask a trial judge to excise portions of a autopsy because it showed prior injury, and we don't want to taint the field with any prior injuries. To me, that's a very untenable situation for any district court judge to go through and piecemeal what is scientifically valid for the purposes of proving this particular crime, as opposed to other scientific aspects that might be part of the autopsy.
Yeah, so again, that's what I just said. I didn't mean to get ahead of the district attorney here, but again, yeah, it would be strange to the jury to omit prior injuries from the full autopsy in the Kaleb Hogan case. And yes, I would imagine it's going to be hard for a judge to want to omit those prior injuries from an autopsy, right? Because we're talking about a 3-month-old child here. So I can understand the argument where it looks like, why would you want to omit these prior injuries to this child when he's only 3 months old? What those prior injuries mean is that Malykai suffered his entire life. And I still do think that's important to this case. I mean, if it were, and I'm not a lawyer, but if I were the defense, I don't think I would have tried to omit the prior injuries. I probably would have just hammered it home to the jury that no one knows who committed the prior injuries.
That may not comport or may make somebody look bad, or would even be constituted or argued by a lawyer to be a prior crime or bad act. That is to say, that autopsy is its own document, which is objective in nature. It's presented to be objective, and that's going to include every injury or every disease, height, weight, everything. And so that was part of the motion in limine, but filed by the trial court defense, which was to excise those portions, excise the prior injuries to the child, because we couldn't bring that in. And he puts that in line with, in parity with, the defendant's statements, which he says, there was soft shaking. There was even mention in the interview that occurred in Newton with Captain Ralph, that I believe the defendant said he had the child in a car seat, might have bumped the car seat and caused some kind of prior injury. And so there was supplemental information.
The car seat he's got, this is wrong. As far as I know, no car seat was bumped. I don't think he said anything about bumping a car seat. What he's referring to is that child carrier that the Malykai's primary care provider originally blamed the bruising on the ribs from. Remember, Kaleb and Malykai's grandmother noticed the bruising on Malykai's ribs, and so they took him to the doctor. And his doctor said that they couldn't really think of why, other than perhaps the child carrier that they were carrying Malykai around in. Not like a car seat carrier, but one that we strap to our chest to carry our children around with us while we're going about our daily lives.
With regard to what prior injuries might have occurred, but they simply weren't credible. And it appears to me that at the end of that motion in limine, and if you go through and read the transcript of the motion in limine, there are three items really up for grabs. One was the autopsy, one was the statements of the defendant, and the third was the admissibility of the polygraph testimony. The state very clearly said, we're not going to admit anything. We're not going to mention polygraph. We don't take issue with that. But the other issues with regard to
the polygraph, let's touch on the polygraph real quick. So he says the state had no problem leaving out anything about a polygraph. To the best of my knowledge, Kaleb was asked before his second interview, the second interview being the one where he made his minimized confession, according to police. He was asked prior to that interview if he would come in and take a lie detector test. Kaleb agreed to come in and take the lie detector test, and as far as I remember, they never administered it to him. What I assume happened is that the police were going to have him in there, and they weren't going to get anything out of him, and then they were going to have him go take the lie detector test. But this is common misconception that lie detector tests are 100% accurate. They are not. I would say they're not really accurate whatsoever, but what they are good at is an interrogation tactic to see if a suspect is going to be comfortable in a position where they feel like they cannot lie. But because there are so many false positives and correct or false negatives, whatever, because there's so many false positives, they're not admissible in court. They're not accurate. All they are used is as an interrogation tactic by police. And I think is it Chris Watts, I believe in 2018, he did take that lie detector test and he failed it. And he ended up being guilty. He did admit to it. But again, if you watch that lie detector test with Chris Watts, you understand why it's a effective interrogation tactic.
The autopsy and the statements of the defendant seem to go towards credibility. The trial court is the one who frames the response to the defense. And when he does so, he says, I see this as 455 evidence. I see this as absence of mistake or accident. This is 6455. He says, however, that is balanced against the other use of this information, and that is one of credibility. And when you look at the statements that the defendant made with regard to
Okay, so let me find my notes here. Hang on one second. So what he's saying here is that actually Kaleb's defense attorney is not the one who called this 6455. What the district attorney is saying here is that all they did was argue to strike the prior injuries from the record. And then what happened was that the district court, being the judge who was presiding over Kaleb's case, is actually who decided that this is 6455. So again, defense only tried to strike the prior injuries just on grounds of them not being proven, and the district court is actually who called this 6455.
contact that he had with the child and even categorizing them as a confession, I think that's, by the way, I think that's still accurate. And it was a confession. It was a confession of the fact that he isolated the timeline that he was with that child. It was a confession to the fact that he had hands on this child. And it was a confession of the fact that he at least shook that child, and he demonstrated such on video.
And he's not wrong, right? And again, I've said it before, I'll say it again. I do personally believe he's innocent, but I believe it is completely fair and necessary for the jury to have an opportunity to challenge the credibility of those statements. And, since we're already on the subject, let's get into credibility real quick. I think maybe we touched on this earlier. But again, and we all know what credibility means, but let's talk about it in the context of a legal proceeding. Credibility refers to how believable or trustworthy a witness or defendant's testimony is as judged by the jury or fact finder. It is assessed based on factors like the consistency of their statements, their demeanor on the stand, any corroborating evidence, and their character or past behavior. But it has to be relevant and follow evidentiary rules. Juries are typically instructed to weigh credibility based on evidence presented, not assumptions or bias. And let's go down here. The relation to KSA 6455, this statute governs the admissibility of prior crimes or bad acts. We're going to get into prior crimes or bad acts as this video goes along. This statute is relevant to credibility because improperly admitted prior act evidence, so prior injuries, can unfairly damage a defendant's perceived trustworthiness in the eyes of the jury. For example, if the state introduces evidence of past misconduct to suggest the defendant is likely guilty, such as propensity, which we touched on earlier, it can prejudice the jury's view of their credibility, even if the evidence is not directly related to the current case. So, once again, like I said, the reason these are all highlighted the way that they are is to show that all of these definitions kind of bleed in. You can't have one without the other, right? Did I lose my spot? I'm sorry. So if we don't know who caused the prior injuries that we saw in Malykai's autopsy, if we don't know who caused them, why are we just giving them to the jury? If you've got a defendant in the hot seat and they're charging him with the death of a child and they're seeing the prior injuries and there's no context offered, who do you think did those injuries?
Let me ask you a question. So do you agree with the trial court judge and also, Justice Stegall, is this evidence of a prior bad act or a prior crime?
In all honesty, when I reviewed this transcript, and I was not the trial attorney on this case.
Sorry to keep pausing this. Let's go over prior crimes and prior bad acts. Sorry, I didn't realize how close we were to this point. So a prior crime is a specific act that led to a criminal conviction or adjudication. A prior bad act is a broader term covering any wrongful behavior, whether or not it resulted in a conviction. Both of these things can be used in court to prove things like motive or intent, but only if a judge finds them relevant and not too prejudicial. Remember that. Prior crimes carry the weight of a legal finding, while bad acts may lack formal proof, making their admission trickier. That's why we're here today. Prior crimes or bad acts cannot be used to weigh propensity, even if they are proven evidence. We can't use prior crimes or bad acts to weigh whether or not somebody is propensive or has a disposition to commit crimes. That's the law. Okay, did I miss anything here? Okay, and so what I think Justice Spiegel is asking him right now is he wants the district attorney to define, are we talking about a prior crime or bad act? Let's pay attention to his answer. And let me make sure I am in the right spot. Okay, here we go.
I reviewed this transcript. That the first boring question I had in my mind was, is this 6455? Is this a prior crime or a bad act? Now, certainly we don't use the title of a statute to define the content of a statute necessarily. When I look at this, I had trouble finding this to be a prior crime or bad act, kind of in the idea of propensity of violence.
Okay, let me ask you this. Could the dad...
There you go. Right from the horse's mouth. The district attorney, the lead prosecutor. I had trouble finding this to be a prior crime or bad act weighed as propensity or how propensity permeates through the case because of this prior crime or bad act.
Have been charged for the prior shaking as child abuse because of the injuries to the dad.
I had trouble finding this to be a
I wanted to make sure that we are I didn't mean to skip over that. I just want to make sure that we get to hear this real quick.
prior crime or bad act, kind of in the idea of propensity of violence.
Okay, let me ask you this. Could the dad have been charged for the prior shaking as child abuse because of the injuries to the ribs?
Could he have been charged? I would say, I'd probably give you the same answer I'd give with regard to any crime, Justice. And that is, if there's probable cause to believe he's committed all of the elements of that offense, and we have sufficient evidence to believe that he was actually the person that did that.
Mm-hmm.
But I think it is far more specious for me to say that we had enough evidence.
So are we saying that there was not sufficient evidence to charge Kaleb with the prior acts? She just asked, can the dad be charged because of the injuries to the ribs? And he says, I'll give you the same answer I give just about any. If there's probable cause to believe that they caused it, then yes, we can charge them. So my question is, why didn't we charge him with the prior injuries?
Evidence to charge him with that second event. I don't
No,
believe.
I want to focus on whether the trial court judge said it's 6455.
Right.
It's prior bad act or a prior crime.
Sure.
All I want to know is whether you think that's true. that the prior shaking softly with, in combination with the healing rib injuries, whether that would be a prior crime or prior bad act. In other words, was the district court correct in saying this?
I would love to give you a black and white response.
So I would love to hear a black and white answer.
So she just asked him, did the district court err to admit this evidence? I'm going to make a tally of how many times District Attorney DeVinny is asked if the district court, being the judge that presided over Kaleb Hogan's case, erred in how this prior evidence was allowed to be admitted and given to the jury. That's number one on the tally.
I can't. And I'm sorry, I can't. Because I don't know the nature, I don't know the circumstances, and they're not fully developed. And in order to get more of the story from Mr. Hogan is exactly what went down with the prior injuries.
Well, can we
What I
say
have is-
Isn't that the
committed a crime?
point?
I'm sorry.
Can we say someone committed a crime? And then that gets to this defense argument that the state inferred it was Mr. Hogan, but yet there's no evidence that it was Mr. Hogan.
I think the prior injuries, and I have to keep my mind broad every time I hear about child victim injuries, I would need to know more before I would say, yes, that's clearly criminal conduct.
Okay, so let's say that it is. Let's say it's a prior crime or bad act. Let's
Okay.
go with what the district court judge concluded. It doesn't seem as if anybody objected to his characterization that way. So then what happens is it can't come in unless but it can be used. It can't be used for propensity, but it can be used for motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or accident. And if it is one of those, then the court.
Let's go over propensity one more time. Again, propensity refers to a person's inclination or tendency to engage in certain behavior, particularly criminal or wrongful acts based on evidence of their prior conduct. The statute generally prohibits using prior crimes or civil wrongs to demonstrate. And so you can start to see now why I have certain parts of these definitions labeled in different colors, right? We are prohibiting using prior crimes or civil wrongs to demonstrate a person's propensity. Well, what do we see if we come down here? Prior crimes or prior bad acts. Prior crimes or bad acts cannot be used to weigh propensity, even if they are proven evidence. They can be used to prove things like motive or intent, but only if a judge finds them relevant and not too prejudicial.
Has an obligation to determine whether the probative value outweighs its prejudicial effect. And so let's say that we find it's probative, okay? Did the district court err in failing to say anything about the prejudicial effect?
This is the second time the DA has been asked if the district court erred.
Well, actually, when you look at probative value, let's look at probative value. Here's what we're supposed to consider. And this is under the Clarehout decision from 2019 that we issued. So when he's just talking about probative, how clearly was the act proved? The prior bad act. Okay? How probative is that evidence on what is being charged in this case? How seriously disputed the material fact is, and whether the government can obtain any less prejudicial effect. Okay? You could say that the judge found probative value, but I don't see that any of these things were considered. But then you have to go to prejudicial effect, the likelihood that the evidence will contribute to an improperly based jury verdict, distract the jury from the central issues of the trial for this particular act, and how time-consuming it would be to prove the prior act. But of course, they never proved the prior act, so it wasn't time-consuming. But I just don't understand, did the district court err in doing all this? It just seems like
Number 3.
There was absolutely no weighing of probative value versus prejudicial effect.
It seems to me, this is what she just said, it seems to me there was no weighing of probative value versus prejudicial effect. Let's go through these real quick. We went through probative earlier. Probative refers to evidence that tends to prove or disprove a fact or issue relevant to the case. Prejudicial effect. In Kansas law, prejudicial refers to evidence that may unfairly bias or influence the fact finder, typically by evoking an emotional response or suggesting guilt based on irrelevant or improper grounds. Evidence is deemed prejudicial if its potential to cause harm, confusion, or undue influence outweighs its probative value. So again, we can see here under prejudicial effect, I have the part about probative value highlighted blue because probative itself is highlighted blue. All of these, they're like gears in a transmission. They have to work together. If one fails, the rest of them fall apart.
And if I'm to understand correctly, it's the statements that the defendant made that are inherently so prejudicial, or at least that's how you're couching that question or the point that you're making?
No, bringing in the prior bad act or prior crime of the previous shaking 6 weeks earlier that they are asking the jury to infer that he committed that crime.
Sure.
Because of the old.
If I may just add some context here, that you may want to add into this, your answer to Justice Standridge. All I could find in the limine transcript, motion limine ruling, was the judge making this passing statement. And the court finds that the probative value of the 6-week-old injury evidence outweighs its prejudicial effect. And then he goes on to say, I will need to give a limiting instruction.
So it sounds like the district court, Judge Rickey, again, when I say district court, we're talking about the judge who presides over the case. He says that the probative value of the prior injuries, especially as how they relate to the minimized confession that they're building the whole case around, the probative value of those prior injuries outweigh the prejudicial effect. He says, I will need to give a limiting instruction. Remember, the court, the state of Kansas, not the defense, but the court is who called this 6455. And if we're talking about 6455, then we have to give limiting instructions about how a jury can weigh evidence. And if we remember, let me go up here real quick. Let me give me 1 second. I'm trying to remember where my note was on this. On judge instructed jury that they may consider prior injuries only to find Kaleb Hogan guilty of child abuse, not murder. They instructed them to weigh it whether or not Kaleb acted knowingly versus accidentally. But again, how does the probative value outweigh the prejudicial effect? How does the jury decide if Kaleb did this knowingly or accidentally if we never proved who did the injuries in the first place? And I'm not trying to sway you one way or the other. I just want to make sure everything is clear.
If there's something more in the record that I missed, you might point that out to us as well as you talk to answer Justice Standridge's question.
Okay, trying to address both of you equally, but I'll address this first, if I may, which is I'm not aware of anything else in the transcript where there's an elaboration of the probative prejudicial balance with regard to this.
So those factors that Justice Standridge mentioned.
Right. So no, I'm not aware of any well-developed, I guess, like I said, transcript or the fact that colloquy might have occurred even beyond the transcripts. But I'm still struck between the idea of we have probative prejudicial, which is we weigh that for every bit of evidence that we have and use for trial to distract the jury, and that was one of the factors that was mentioned as well. But this wasn't, the case was not reliant upon the prior injury. This evidence was admitted, but again, how do you pair out?
I'm just talking about when, the judge made a decision here. The judge's decision is reviewed for abuse of discretion.
Sure.
One of the issues, one abuse of discretion is an error of law. Why isn't this an error of law that the judge didn't even consider?
This is the, third time he is being asked, did the district court err? Is this an error of law on the part of the judge? He is not answering their questions.
The prejudicial effect, let alone, the elements of the probative value. But you could say, well, but he talked about the probative value enough that, he doesn't have to state, or she, I don't remember who the judge was, but state everything on here. But there's just no contemplation of all, which, it seems like that the prejudicial effect might be a pretty big issue.
It seems like the prejudicial effect might be a pretty big issue. Remember, are we talking about a technicality here, or are we talking about a case that is flawed from the bottom up? If you don't have a good foundation, the whole house crumbles.
I think undoubtedly, every time we look at 6455 evidence, we always worry about the prejudicial effect.
Well, this
This is why
judge really,
455 is a statute.
Yeah.
This is why we have it codified. and this
did
is
the
why-
district court judge err? Did the district court judge abuse its discretion?
I think those factors need to be weighed.
What is that, the fourth time? The fifth time? Did the district court judge err? I think those factors need to be weighed. Yeah, they need to be weighed, and that's why we're here today. Why are we not answering this question on whether or not the district court erred in their decision?
I think the fact that the transcript does not necessarily contain that balance of going through the probative versus prejudicial at length with regard to the factors.
At length?
There was no length. He just said, but absolutely. I can't change the transcript, but
Summary conclusion.
You can't change the transcript. Let's back this up real quick.
there was no length. He just said, but that balance of going through the probative versus prejudicial at length with regard to the factors.
At length?
There was no length. He just said, but absolutely. I can't change the transcript, but
Why do you need to change the transcript? If you have a solid case here, and again, I saw people online saying that, well, the conviction was Kaleb's murder conviction was overturned because the district attorney fumbled during the appellant hearing. If you have a solid case, a slam shut case, the first time around, how do you fumble it the second time? I don't understand that. We're not talking about opinions here. They should have a slam shut case here, right? A guy got life in prison. Malykai is gone, and nobody admitted to it. But if you're so sure in who did it, how do you fumble that the second time?
Summary conclusion.
But I think that was also it was a summary conclusion, but the debate, the back and forth, I think if you look at the entirety of the transcript of that hearing, was considerably longer. The content of what it is that's being addressed here, the trial court gauged.
It all went to probative value. The whole transcript.
Sure, but the court's rationale was also focused upon the admissibility of this information under credibility issues, 6421, 422, those types of matters.
Well, let's just, what if, just for a second, pretend that the court infers that finding is made. why isn't this prejudicial? What is the case for it not being prejudicial?
What is the case for this prior evidence not being prejudicial? If you've made it this far and you're still on the fence on whether or not this overturned conviction is based on a technicality, this is the DA's chance to prove me wrong. This is the DA's chance to give factual, legal reasoning, not just legal reasoning, moral reasoning, why this is just a technicality that Kaleb's appeal lawyer is trying to get at here. If this is a technicality and Kaleb Hogan and his defense are just grasping at straws, DA DeVinny, now is your chance to prove that. Let's see how this goes.
Because I think it strikes me that the explanations for its admission, credibility, meaning that he didn't gently shake, he actually abused the child, and not a mistake, meaning that he did those prior things. It seems an argument might be made that propensity sort of permeates those rationales. But I want to hear.
Again, real quick, propensity, right? We know propensity by now. We've hammered it home. This refers to a person's inclination or tendency to engage in certain behavior, particularly criminal or wrongful acts based on evidence of their prior conduct. And remember, we cannot use prior crimes or bad acts legally to weigh propensity, even if they are proven evidence. And this is not proven evidence. So what he's saying is propensity is permeating your arguments for why the defendant is guilty. I'm sorry to keep pausing. Let's listen to what he says.
Your argument as to why that may not be the case. And
The first part of what you proposed was, isn't this actually prejudicial? And I would say absolutely. Everything the state presents
unduly
is prejudicial. So it's really the balancing test of probative versus prejudicial amongst, it also has to be relevant and et cetera. We know these things. But
I guess the question is, why doesn't the prejudice outweigh?
It's really the risk of undue prejudice. I mean, sure, what you're saying is
sure,
a lot of it's prejudicial, but here the weighing is, does the probative value outweigh the risk of unfair or undue prejudice?
my answer to you is it was accurate in this case to admit this evidence. And I go back to what I opened with, which was the statements of the prior injuries. The jury needs some explanation of the fact that we're looking at an autopsy of a dead infant that has prior injuries. Is nobody to address that?
And
is that not to be explained to the jury? And so
No one has addressed Malykai's death. No one has confessed to it. That therein is the issue.
in doing so, we have to say, and the state played their cards. They said, this happened to this child. He's not charged with these crimes. We don't know whether Kaleb Hogan committed those injuries to the child 6 weeks before the death, or somebody else.
Right. And that's what I would like for you to focus on right now.
Okay.
If a judge's ruling can be right for the wrong reason. So if for argument purposes, we assume 455 doesn't apply because you can't prove that the defendant did a prior crime or civil wrong that relates to that prior injury. So set aside 6455. You have an autopsy that has evidence of a prior injury and a current injury. That has to be sorted out somehow. What was caused recently? What was caused long ago? Is there an interrelated effect possibly? What is your strongest argument that the evidence of the old injury to the ribs, to the brain, was relevant and probative to the charges in this case?
best argument I have is that
I'm sorry, material and probative. Those are both things that are subparts of relevance, and all relevance is presumed to come in. So what's your best argument? I'm sorry, I misspoke. That evidence of the old injury was both probative and material.
probative as to the defendant's credibility regarding the statements he made. He told law enforcement officers that interview with Captain Ralph that the prior injuries might be connected to he mentioned something about he was in a car seat, might have bumped the car seat, and he had some kind of contact that may be related to the prior injuries. It was a minimization on behalf of the defendant, just like it was a minimization when he later described the shaking that he did with that child, and he minimized it. Now, in both circumstances, this is a question then of the credibility of the defendant and how that's weighed.
So evidence is
Okay. So for the umpteenth time now, the district attorney has been asked several times, did the district court err in admitting this evidence and showing it to the jury the way that they did without charging him, which lowers the state's burden of proof? He is asked. He's told, set aside 6455. What is your best argument for why the prior injuries to Malykai Hogan are probative, right? We remember probative refers to evidence that tends to prove or disprove a fact or issue relevant to the case, and material, which refers to evidence or facts that are relevant and significant to the case, having a direct bearing on the issues being decided. Material evidence is essential to proving or disproving a key element of a claim or defense, such as intent, identity, causation, and is admissible if it impacts the outcome of the case. Material and probative, she says this, material and probative are all subparts of relevance, wherein all relevance is presumed to come in. And what is his response? Devaney attacks Hogan's credibility and uses the quote-unquote car seat, which is incorrect. What he's referring to is the child carrier. And he uses his minimized confession to argue relevance, materiality, and probative value. There's no mention as to why the DA presumes Kaleb is not credible. He says he's not credible, but he doesn't give a reasoning why. Remember, this car seat / child carrier issue on its own is not really a minimization on behalf of Kaleb, because Malykai's primary care provider is who suggested to Kaleb and Malykai's grandma to switch child carriers. Kaleb found the injuries, the bruises, took him to the doctor, and brought attention to it before anyone knew he was suffering, except whoever it was, again, that was the perpetrator. Malykai's doctor is who told Kaleb and Kaleb's mother that it was not something to be concerned about and to try a new child carrier. But he's using this car seat / child carrier thing to argue that Kaleb is not credible. How is he not credible? He's stating what happened.
probative if it has any tendency to prove a material fact where, a material fact is a disputed material fact.
Sure.
So was his credibility, what did he lie about?
I believe that he completely minimized the fact. He never said, I killed this child by this means and thoroughly went through it in great detail. He minimized it. His credibility, the defendant's credibility in those statements have to be tested, have to be aired out in front of the jury. And it's the jury that has to decide whether or not he is credible. Those statements, or the statements.
Yes, he's right. The jury has to decide if he's credible. You have to give them the proper tools to decide if he is credible.
That he made were credible. That's essential in this case as well as most others, actually. was the defendant, any statements that the defendant made that are admissible, have to be tested for credibility. Just like-
So doesn't that swallow the whole rule then?
I'm
Because
sorry.
credibility, you can't use it for propensity evidence,
Sure.
but even though it's not listed in the statute, as Chief Justice Lukert mentioned, but if you're saying that everybody's credibility is always at issue, doesn't that swallow the rule of, well, propensity evidence can always come in?
No, I think that if it's going through the route of 6455 and is one of those 8 identified factors,
Which credibility is not one of.
absolutely. But that's just it. If it's one of these factors, which again, the trial judge determined, he was the one that advanced the theory that this was 6455 in that motion in limine hearing. The state was looking at this going, this is mere credibility issue. We're going to admit the autopsy. We're going to have some explanation as to the prior injuries. And it was in response to the defense initiating
Well,
this.
it's so bad to not have the prior injuries in.
I'm sorry, why would it not be so bad?
Right. I mean, couldn't you prove the case without the prior injuries?
Couldn't you prove the case without the prior injuries? So again, to the people who may think that this is a technicality that we're getting off of, she is asking the DA, I am asking you. If we're just talking about a technicality here, then what's the problem with excluding the prior injuries to Malykai in this case? Couldn't they have just proved that Kaleb did cause the injuries that happened to Malykai that caused his death on March 23rd of 2021?
You could, but that would also require, like I said, a trial court to then start excising every autopsy to determine what is scientifically relevant to the death versus not. Can we talk about this? Can we not talk about that? And
Or could there have been a limiting instruction that just said you can't weigh those prior injuries against Mr. Hogan?
well,
If there's no evidence.
and that's where I think, if nothing else, the saving grace and I don't mean to be ever to be flippant about our judicial system here. I have yet to be part of a perfect trial, no matter what it is. And I think that as the course of this case went through, Judge Ricky heard this evidence on this motion in limine. He anticipated, hey, it's seemingly 6455 to him. And if we are going to do 6455, the law is going to require that limiting instruction. And he proposed at the end of that motion in limine hearing, I'm going to go ahead and prove that, make sure it's in the journal entry of today's hearing, that we will have a limiting instruction. And then certainly when it came to trial, there was a limiting instruction.
And it was not objected to.
Correct.
We're in clear error land. And one question I have about as we get to that area, do you consider the objection that was made, so that as I understand, the procedural history of this was that there was the motion in limine ruled on, then at trial, when the forensic pathologist was testifying, defense renewed their objection to the admission of the autopsy report. The judge ruled that the autopsy report and related testimony would be admitted, and defense counsel made a continuing objection. Do you understand that continuing objection to be to any evidence of the prior injury throughout the trial, not just to that witness? Or do we, when we get to harmlessness, consider the fact that it came in multiple times in the trial? And I mean, just what was the effect of the continuing objection?
I think I would be in the treacherous area of divining what those words meant from the transcript. I would say that I would just have to rely on the transcript of the trial. I think that, and that's all that was said, I believe, which is, I noted the continuing objection.
And I noticed the state didn't, or hasn't argued preservation of the,
Yeah,
so I take it, you take it, the continuing objection does apply to the trial.
I would anticipate it as such, and I think with regard to the reservation, to me, the context of that when I went through those transcripts were, this is what this is referring to, and we'll refer to someday when we're before a higher court.
This is what we're referring to someday when we're in front of a higher court, almost as if Perhaps they were anticipating getting to this point. I don't know. So again, what she's addressing is, I mentioned this, I think, probably towards the very beginning of this video. Kaleb's defense during the trial several times objected to the admission of the autopsy, anything that had to do with the prior injuries. And again, the actual argument of excluding the evidence, the jury was not in for. They sent the jury out after an objection was made. But how it would work is they would admit the autopsy, and Kaleb's defense would object. The jury would be sent out, and Judge Rickey, the district court, ruled that they were still going to admit the evidence anyways, and then the jury's brought back in. So what you had was the jury just saw the defense object every time prior injuries were brought up. So I would argue they probably thought that he was being a sleazeball defense lawyer, a public defender. And, excuse me, the reason I would argue that is because that's kind of how I felt when I was in the trial. I mean, I'll be honest. Because, again, I didn't understand what any of this stuff meant when I was sitting there in that trial. And the jury certainly doesn't either, because they have less information than I do. It just made Kaleb and his lawyer, in my opinion at least, kind of look like they were grasping at straws. So, and Kaleb's my best friend, so if I thought that, then what do you think the jury thought?
Okay. Any other questions?
Hopefully this is real quick. But it refers back to an earlier question Justice Standridge asked, which is about charging for the prior injuries.
Mhm.
Presume the state's theory of this case was that the defendant had abused the child 6 weeks earlier, and then the incident that caused the death, right?
I'll stop you right there. No. What the state's theory was, he committed acts, I believe, on or about March 23rd, 2021, that led the acute injuries on that date led to the child's death.
Had you charged the defendant with the abuse that occurred 6 weeks earlier, all this evidence would have come in, right? There wouldn't have been any question about 64.
Absolutely.
So my question is, isn't one of the purposes of 6455 to essentially tell the state, look, you can bring this evidence in, but what we don't want you to do is allow a jury to consider essentially that it lowers your burden of proof. Like if you had charged him with it, then you have a high burden of proof.
It lowers, exactly. So what he's saying is that the state doesn't have, they don't even have to prove to the jury or to anybody that Kaleb did those prior injuries. If they would have charged it, they would have had to bring in evidence to back up their claim that he did that he did the prior injuries. But they didn't bring in, or I'm sorry, they didn't charge him, so they had no burden of proof. And as a matter of fact, the jury had no context. Again, remember, I mean, we're talking about a week-long trial, and they might have glazed over it once or twice that it was never proven who did the prior injuries, but they did not send that home, right? It was not, if it didn't make sense to me, someone who at that point who had come to terms with most of the facts of the case for the better part of 2 years, if I didn't understand that, how does the jury understand that? All they had was the prior injuries and the current injuries and a defendant in the hot seat who the state was claiming made a confession. And to be fair, I mean, they weren't, again, and they even said it a few minutes ago, the case did not rest on the prior injuries. He just said it. He said, I'll stop you right there. Their argument was that on or about March 23rd, 2021, that Kaleb Hogan caused acute injuries to Malykai Hogan, which did then cause him to die. And you know, they had other things too. They used Dr. Weeks' testimony that it was a shaking. And the defense, again, they brought in Lyle Nordhook, the forensic pathologist that challenged Dr. Weeks's claims that it would have had to have occurred moments to hours before. But Nordhook came in, who independently reviewed the autopsy, and said, no, we're talking 12 to 24 hours before, so we've established here in this video by now, I would hope, that we haven't proven who did the prior injuries. And on that note, I don't think we've proven who did the acute injuries, because we have a disputed timeline here. It really just, honestly, all of this comes down to credibility. I can highlight all of this until I'm blue in the face, but this comes down to credibility. Who do you think is more credible? Kaleb Hogan or the mother? And we don't need to get into the mother. Or who do you think is more credible? Dr. Weeks, who says the acute injury occurred moments to hours before Malykai stopped breathing, or Nordhook, who says 12 to 24 hours before Malykai stopped breathing? Again, I don't want to steer you in any one direction or the other. That wouldn't be fair of me. But I'm asking you, if you made it this far, have we proven who did anything here? Because there is nothing about this case that is not disputed other than the fact that Malykai Hogan is gone.
You could have got this evidence in by charging it. The concern in 6455, the policy concern, I think, is, look, we don't want a jury to consider unproven allegations as propensity evidence. And that's how I understand the defendant's primary argument. So I just wanted you to respond to that based on the purpose, the policy purpose of 6455.
Well, what you are discussing is the initial charging phase and how the initiation of a prosecution for the purpose of looking at what all evidence might be admissible in trial and ultimately potentially lead to a conviction. I don't agree with the premise that 455 is somehow directive of going, hey, prosecutors, make sure you charge everything at the get-go of this case. Add more crimes so that way it comes in and then you don't have to go through this gateway. I think 6455, first of all, was not anticipated nor filed, that we did not initiate this as a 6455 admissibility issue. This was something imposed upon us by the trial court. Defense opened the door to it. When you talk about the state's theory or how we should progress or how we should even charge this, not on our radar until that hearing that day, until the hearing on the motion in limine. And that's the first time it was discussed as 6455 because that was postulated as being exclusion or necessary to be excluded by defense counsel. So the court says this is 6455 and he couches it under the two rationales, one of credibility, the other under 6455 absence of mistake.
I understand all that. I guess my point is just I'm questioning whether or not, and I think you said you don't agree with me, but 6455's purpose is to eliminate ghost charges. You can't have a ghost charge that you don't actually have a burden to prove.
Yeah.
No, I see.
If you disagree with that,
honestly, I've never contemplated it in that fashion. I really haven't. And is that a directive of sorts? And I guess if so, it's either a subtle one or I'm a dullard and never caught on to that. But I believe this is about. I don't believe that our existing law under 455 is using this evidentiary rule as a directive, as a signal or a beacon to prosecutors of make sure you charge everything for admissibility.
And in this case, I agree with Deveni, right? You can't use this avenue to just charge everything possible to any defendant, right? We can't throw stuff at the wall to see what sticks. Although, in this case, if they were arguing. Well, okay, they weren't arguing, right? They were just inferring or implying that the prior injuries were caused by Kaleb Hogan. Okay. So if you're okay with inferring that, in my opinion, again, Malykai died of homicide. This is murder. Okay? In my opinion, if someone kills a child, you have my explicit permission to throw stuff at the wall and see what sticks. Let the evidence do all of the talking and let the jury decide where that goes. Let the cards fall where they may. Just my opinion.
I think that's some five-dimensional chess going on, if it is. And so, again, maybe I'm just don't have the wisdom to have looked into it under that light, but I respectfully disagree that that's the assessment.
But it was always your intention to talk about the prior injuries with the jury, right?
It was always the state's intention to admit the autopsy in full.
Which would include the prior injuries, which would have, it's not like you were going to put this in and then not talk about, I mean, you just can't just let it lay there. Right?
That was the quandary we were in,
I don't care about the quandary. Your intention was to put evidence of prior injury in front of the jury, right? That's what was going to happen with what you were going to do.
Yes, the autopsy. Yes.
Well, isn't it possible that that prior injury somehow is relevant to the seriousness of the current injury? That perhaps he was right, and the defendant was being truthful. I only shook him gently. And here we have evidence that something else happened to him before, and that may have contributed to what very little I did, or which would minimize his culpability.
It would, but the coroner and pathologist, they both testified and said that there were prior injuries, but it didn't capitalize on that, and there was some severability, I guess, with regard to those healing injuries. They said that there was evidence of old brain bleed and healing rib fractures. I believe at the time the child died, the child had 16 broken ribs, but noticed that 6 of those were healing. And
it could have benefited the defendant to say, look at all these other things that happened to this poor child, and we don't know who had access to him or who did those things during that time. But what I did not cause his death.
And I think that's what he did proffer. And I think that's what was put forward at trial, and he did advance that theory.
Is that?
No. Now that I disagree with. I don't think this was proffered at all at trial, the way that DA Deviney is saying. Now, and that said, Kaleb's lawyer defended him passionately. But there are several times he got emotional, he tripped up on his own words, and failed several times during cross-examination of both witnesses prosecution witnesses and defense witnesses. He did, at least to me, come off as a little bit sleazy sometimes. And this is, I believe in his cause, but I can remove myself far enough to again, he did it passionately. His heart was in a great place to defend Kaleb the way he did. But he got tripped up on his own words. And he did not, the non-proof of the prior injuries was definitely touched on, but it was not discussed in detail. And his defense attorney went all over the rails. And that's not Kaleb's fault. And that alone doesn't mean that he's innocent either. I'm not making the case that he is innocent just because his defense attorney was being a goober. And again, just to touch on this one more time, I agree with the DA's assessment that you should not just charge everything possible as a means to circumvent 6455. But I cannot think of a single reason why they couldn't have charged the prior injuries in this case. Because it wouldn't have harmed them whatsoever. The jury doesn't have to convict every charge. They could have ended up finding Kaleb not guilty of the prior injuries, but still finding him guilty of the injuries that caused his death, Malykai's death. They don't have to do all or nothing, right? There's no reason for them to not charge the injuries in this case. And again, why do I wish they would have charged the injuries? Because it would have raised their burden of proof. They would have had to have touched on it more. Again, remember, the only mention of these prior injuries is in testimony to give context to how Malykai was during the autopsy. And it was obviously in the autopsy, right? So there's no reason to not charge that. It would have uncovered more, in my opinion. There would have had to have been more cross-examination. There would have had to have been more witness testimony as to who was in the who Malykai was in the care of 6 to 8 weeks ago. Sorry, excuse me. All right, let's get through this. We have about 12 minutes left of this hearing. So
Is that relevance to the total evidence without even considering 455?
As to the credibility of his statement,
As to the overall cause and effect of what the doctors found when the child was on the table, deceased?
relevant to explain the evidence to the jury so they could make a reasonable decision. Yes. It is relevant to the res gestae, the body of this case. Say you have a child who's 3 months old, has 6-week-old injuries that are healing, has present acute injuries that led to the child's death. You have the only people that say that they had any type of physical contact that would have led to injury is the defendant, Kaleb Hogan. He's given statements about the past injuries, but the present injuries seem to be minimized. As a result, his credibility becomes extremely valuable.
They seem to be minimized. I hate to put it this way, but it doesn't matter how bad something looks. That is not how we handle our criminal proceedings here in the United States of America. And I hate to sound like an old man about it. And maybe there's a better way to put this, but facts don't care about your feelings. Just because he seems to have minimized does not explicitly prove guilt. Not for the prior injuries, not for the current injuries.
When you look at that in total with the autopsy and the prior injuries and the knowledge that all of that needs to come out, shedding light on what is the story was, shedding light on what the defendant had to say, and trying to explain to the jury even-handedly, and with the inclusion of a limiting instruction with regard to how to use that evidence, was the best protective that we had under the facts of this case.
So
Is
you
that
just,
relevant even if you assume he did not do the prior injuries?
I think defense could advance that theory that he did not do the prior injuries, but
But is the
I don't know that
relevance-
any of us know that.
Is the evidence of the prior injury relevant if you assume he did not do those prior injuries?
Let's assume he did not do the prior injuries, but he did do the acute injuries. Remember earlier, Justice Spiegel asked, why do we even need the prior injuries? Couldn't you prove the case with the acute injuries? I'm going to let Devaney speak for himself on this one. Pay attention.
Because 6455 only applies if he did.
Mhm.
So if you assume he didn't, what's your best argument that the prior injuries are still relevant in being material and probative?
If I assumed he didn't do it, then I think that the evidence would still have to come in to explain his statements and the fact that there are at least were some injuries and that he is at least among those that were suspected of committing that type of injury. But
It's almost as if this is the first time this guy is considering this as even a possibility. It's almost as if people are not doing their homework here.
I don't know. I don't. I have no idea who committed the injuries or how those injuries occurred from 6 weeks before. Be that the mother, be that the defendant, grandparents, anybody that had contact with that child. So I can't tell you today. I know Kaleb. I know that he committed the injuries from 6 weeks ago, and that's precisely why he's not charged with the crime of child abuse.
Do you need it to tell?
You heard it from the horse's mouth, folks. Do I really even need to explain that? Or does his silence speak for itself? Does the fact that he just admitted on the stand in a public hearing that we don't know who did this 6 weeks ago? Do I need to explain that? Really?
A full and complete story of the existence of the physicality of that child at the time of his death.
I don't even know if I heard exactly what your question was. Could you
Well,
repeat that?
do you need it to fully explain how the child was at the time of his death? Because you have to connect what the defendant did to the deceased's condition. So do you need it to fully explain the condition of the child at the time of his death? Or not?
I believe that the explanation is merited. This child was 3 months old when he died. That's a very short period of time, sustaining 6 broken ribs and then later 16 broken ribs in 3 months. In 12 weeks, this child was horrifically abused, and then you've got the the other injuries as well. I think in total, yes, I think that's going to be an explanation that a jury at least needs to weigh and look into. The jury needs to go, oh, what's going on with this child? Was this child? And I think they would ask the question, but it was explained at trial as well as, did the injuries that occurred 6 weeks before contribute to or accelerate any of the problems that occurred on March 23rd? And it seemed to me when I read through that transcripts seemed to indicate that they said no, they weren't life-threatening 6 weeks ago, but certainly there's still evidence that they're healing injuries. But you're talking about a very short period of time that this child was between birth and death. We're talking about a very narrow window of time here. And to be able to explain that to a jury and say, this is what this child's life looked like in those 3 months, I think is absolutely appropriate. And one of the cautions, I guess, that.
To be fair, I'm not trying to rag on this guy. I think it is appropriate. I think, should this case return to trial? First of all, I think this case should return to trial. Just because I believe that my friend Kaleb is innocent doesn't mean that I want this case to not return to trial. And I don't know how they're going to pursue these charges if it does. But I do think it's important that the next jury understands just how badly Malykai suffered almost his entire life. My kids were supposed to be friends with him. They were supposed to grow up together. He had a right to live like the rest of us. And unfortunately, someone who he was supposed to be able to trust everything to betrayed that trust and hurt him awfully in cruel, deliberate manners on multiple occasions. So the issue here isn't just about Kaleb for me. Yes, I personally believe in his innocence because I have the benefit of knowing him and I have the benefit of the evidence in front of me. But it's not about Kaleb. It's about Malykai. It's always been about Malykai. And to be honest, I don't think any of us are going to rest. Malykai won't rest until whoever did this fesses up. Whoever it is, it's time.
It seemed evident with this from the very moment that the trial judge made the order was, but we are going to give a limiting instruction. We're going to make sure that the jury understands that you can't use this prior injury, that needs to be separated out, and the charges for which the defendant is standing trial is for the acute injuries here. But
is there any evidence that an already injured child is easier to injure?
Well, I think that is possible, but not
aside from what you think. Is there anything in the transcript, respectfully, is there anything in the transcript to indicate that?
No, I don't believe so.
Are there other questions? Okay, thank you, sir.
Okay, thank you very much.
Ms. Davis?
There's a certain point, there's a certain point where it doesn't even matter on which side of the fence you sit on this issue of who is innocent and who is not. Are my tax dollars paying this guy's mortgage, really? Because for a moment, let's put it into perspective. It doesn't matter if Kaleb is innocent or not, because if he did murder Malykai, then this guy just let him out of prison. And if he didn't, the state has not come any closer to proving who did it. This is a problem. Just like Malykai was supposed to be able to trust his parents to take care of him, why do we pay taxes to these people if they can't even have a probative conversation until it's been 2 years? What are we doing? Again, this isn't about Kaleb. It's about Malykai. And this guy right here, the 13th Judicial District of Kansas in Butler County, this is the problem. You need to find out who did it, and you need to prove it. And you need to give a jury of 12 the tools to reliably know who they are convicting. And I'm sorry to end on such a nasty note. This will be the end of Davini's testimony. So once again, if you're watching this in different parts, I'm assuming this is going to be the longest part. So feel free to click ahead to the next video where Miss Davis here, the appellant defender, will be giving her closing arguments, and we will just cover a few of the Supreme Court cases that are referenced throughout this hearing. And if you're just watching this as the full-length video, I know some people like to do it differently. Myself, I like to watch the whole thing at once. That's just me. Feel free to keep watching. We're almost to the end, I promise.
Just briefly, I think what your questions today show is what my brief tried to point out to you, is that the state had the burden to establish the admissibility. And at that motion hearing, the prosecutor was didn't present. And the judge had an obligation as a gatekeeper to hold the state to that burden and to make the state proffer the evidence. And the judge didn't do that.
On that
The
point,
state didn't proffer anything, so the judge just made his own assumptions.
so on that point, am I correct in looking at the record that there was never any discussion of the res gestae exception to 6455 evidence.
No, there wasn't. And I thought Gumby had done away with res gestae.
Real quick, Ray Gesti. Here, 1 second. Let me come over here to my notes. Oops, my bad. Here we go. I have it pulled up on the screen here, but let me go to my notes where I have it nice and easily broken down. So Ray Gesti means spontaneous statements made during an event admissible as evidence because they're tied to the event and less likely to be fabricated. So let's see here. Ray Gesti, though not explicitly, I just read that. So yeah, if I just read this part right here, I kind of just copy and pasted this. That would be kind of hard to understand. But let's read what I have here on contrast with prior shaking admission. Kaleb's later admission during his March 24th interview about quote-unquote gently shaking Malykai 6 weeks earlier wouldn't qualify as Ray Gesti. It was not spontaneous or tied to the March 23rd event, and its admission under KSA 6455 was a key error leading to reversal as it suggested propensity. I should have highlighted that green. I'm just going to do it right now. Oh, no, I'm not. Because I don't know how to full screen my document here. Sorry. So anyways, and I have here, it does not apply, and they're about to explain why it does not apply, but I was quite confused when I heard these people saying Ray Gesti because I hadn't even heard the word before, so I just wanted to give some context as to what they are talking about here.
They has to come in through 6455.
Okay.
So,
Yeah, we
basically-
declared race gesti dead in Gumby. I think,
Yeah.
I think that was almost the words, but
But is it dead?
we have revived it.
Yeah.
I mean, it's been revived. And that's kind of my question. I was waiting for you to get up here. Why isn't it as a part of our extension after Gumby, this come in under race gesti? What's your answer to that?
because the state didn't establish that.
Well, that was
And-
going to be my question.
I mean, we can't-
Are we unable to consider it because it wasn't considered below? And just for reference, in our Sieg decision from 2022,
Right.
we clearly say that, acts committed before, during, or after the happening of
Gunby, Sieg, Claire Hout. We're going to get into all of those in a few minutes. We'll just touch on all of these cases that they're referencing, and we'll do it quickly. I promise.
the principal occurrence, which are so closely connected, form a part of the occurrence, are not subject to 60.
Since we're supposed to object at trial in order to raise issues before this court, you think maybe the state could raise
Yeah, well, that was my question.
issues before the trial?
I presume your answer is yes, we are prohibited from considering race justice.
They needed to come forward and say, this is why we want to. And you know what? There was an omission here because when the judge said, I'm going to admit these evidence because that states, I'm going to admit this evidence. It wasn't just the autopsy report. In the interviews with the detective, he was repeatedly telling the parents, they're seeing prior injuries on this child. The prior injuries were all over everything, right? They were in all the interviews because the hospital identified him that night. Now I lost my train of thought. At the hearing, the motions hearing, when the judge says that, the state's going to present evidence of a causal link between the defendant and the prior injuries. The prosecutor needed to jump up and say, no, we don't have that evidence, Judge. The state wanted this prior injury evidence to come in to show propensity. They were just trying to sneak it on in there, right? The prosecutor never stood up and said, we don't have that evidence, but we want to admit it to give the jury a full picture of this child's condition. And you know what?
And that's how easy it would have been to get this evidence in properly. Just explain to the jury, we have no idea where these prior injuries came from. But what we want you to know is that Malykai suffered his entire life. And that's it.
We have an expert that can say that the prior injuries contributed to the death. The prosecutor didn't say that because they didn't have an expert, because they didn't proffer that evidence. The defense expert said that the prior injuries did not contribute to the death. So really, this is a failure of the state to prove that this evidence is admissible, a failure of the judge to hold the state to its burden to do that, the failure of the judge to act as a gatekeeper. And I did note on the, you don't even need to admit the autopsy report. He's not contesting that the child died and these were the injuries.
And on that note, the appellant defender saying you don't need to look at the autopsy report, that I vehemently disagree with. Right there, all we have here is very, very circumstantial, disputed stuff. If we don't have that autopsy, all we have is his minimized confession, according to police, and after that, the timelines are all disputed. I think the autopsy needs to be looked at. It just needs to be looked at the correct way.
The only reason to get the autopsy report in is to argue propensity. He's not contesting this. And then it was a car seat. It's not a car seat, it's a carrier. The mom bore all day, had the baby in a carrier when the bruise developed. That was what they were talking about. And then just to really clearly, I know I'm out of time, but on the prejudice, it's that the likelihood the evidence will contribute to an improperly based verdict. That's the unduly prejudice. Improperly based. It's an emotion. Emotion and reason are two different horses going in different directions. I think that's Plato. You can't reason and emotion. That's the problem with this evidence. Anyway, I'm out of time.
Any other questions? Okay, thank you.
Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement.
So in closing here, I just want everybody to think of two things. Number one, is this a technicality or is this a flawed case? Number two, always remember, if you ever find yourself in the defendant's chair, guilty or not guilty, the state's introduction of evidence without charging lowers the state's burden of proof. It's beyond a reasonable doubt for a reason. If you ask me, yes, I think Kaleb is innocent, but let's do it again. Charge the prior injuries and let the jury weigh the evidence. Let the cards fall where they may. Okay, real quick. We heard them. We're getting to the end here, I promise. So, very, very early in the hearing, she references State v. Prine. This was a case that made it to the Supreme Court 3 times, at least according to everything that I've found. So let's just get into this real quick and how it relates to Kaleb. So 2009, Kansas Supreme Court reversed Prine's convictions due to the erroneous admission of evidence under 6455, specifically testimony about prior uncharged abuse of his daughter and half-sister. The court found that this evidence was improperly admitted to show intent, plan, or absence of mistake, as Prine's defense was a categorical denial, making those issues irrelevant. Okay, so they overturned it. That's good, right? Assuming he's innocent. No. I want to show a couple cases where this whole probative value versus prejudicial effect ends up not working out in the defendant's favor because the rest of the evidence is so overwhelming. Remember, this stuff can come in if it's deemed relevant. So in 2013, it looks like they had a retrial in 2009. In 2013, it went back to the Supreme Court. The same evidence was admitted under the amended KSA 6455. Remember, it was all the way back to 2019. So I think this actually changed the statute, which allows evidence of prior misconduct in SEX crime prosecutions to show propensity if its probative value outweighs prejudice. The Kansas Supreme Court upheld the convictions this time, ruling that the amended statute permitted the evidence and no limiting jury instruction was required. Right? So now we're at a point where, okay, so we overturned your conviction because this was done improperly. So let's amend the statute let's throw it back out there. The state wants to retry, you get retried. And so in 2013, they decided that, the probative value outweighed the prejudicial effect. And in 2020, Prine sought post-conviction DNA testing of clothing. Tests were inconclusive, showing only an unknown male's DNA, and the district court denied a hearing. The Kansas Court of Appeals affirmed, finding no abuse of discretion. Affirmed means, yes, you're convicted. You get to stay in prison. In good riddance. I don't even want to look at the details of this case. This is disgusting. Let's see. At the time, this statute allowed such evidence only for specific purposes like proving motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, but not to undermine the defendant's credibility or show a general propensity to commit the crime. The court found that the state introduced this evidence primarily to bolster the victim's credibility and to imply Prine's propensity to commit sexual offenses. Again, good riddance. Since Prine's defense was a categorical denial of the charges, issues like intent or absence of mistake were not materially relevant, and using the evidence to attack his credibility or suggest propensity was improper and prejudicial. This led to the reversal of his convictions after the Kansas legislature amended KSA 6455 to allow evidence of prior sexual misconduct in these kinds of cases to show propensity if its probative value outweighs prejudice. The same evidence was admitted at Prine's retrial and upheld as permissible under the new law. So in the 2009 decision, the Supreme Court indeed held that the state cannot introduce 6455 evidence for the improper purpose of undermining a defendant's credibility, as that was not one of the statute's enumerated purposes at the time. The ruling is relevant to cases like State v. Hogan, where similar evidentiary issues led to a reversal due to prejudice from improperly admitted prior bad acts evidence. And you can see, let's do this. Let's pull this over here, and you can have the definitions and everything right next to each other. You can see how, I probably sound like a broken record at this point, but again, I highlighted this so that we could see all the similarities and everything. And the reason they keep bringing up these cases in the Hogan appeal is because these cases effectively change how the next one is handled. These judges will decide that maybe this rule isn't right, and now we need to change this rule. We're going to reference this case. This is why we changed this rule. Let's do, State v. Clairhout. This guy was a DUI, and during the while he was under the influence, he accidentally killed somebody in 2015. So defense argument. Clairhout argued evidence was improperly admitted under 6455, which prohibits prior bad acts evidence to show a propensity to commit crimes. He claimed it was used to suggest he was likely to drive drunk again, unfairly prejudicing the jury. The court's ruling. Kansas Supreme Court upheld the admission. The evidence was relevant to prove Clairhout's knowledge of the risk of a drunk driving, a material fact for recklessness. What's this over here? Material, not propensity. What's this over here? Propensity. Let's see. The probative value of these prior acts outweighed its prejudicial effect. The court found any procedural error in the district court's analysis harmless, given overwhelming evidence of guilt. So if there's overwhelming evidence of guilt, toss it out. Who cares? If they're not going to do it right, well, what does the rest of it say? Unfortunately, in the Hogan case, there's not overwhelming evidence of guilt. Let's see. Again, I'm a broken record, right? Relevance to Kaleb Hogan's case. Prior bad acts evidence. In Hogan's case, the Kansas Supreme Court reversed his convictions because evidence of prior uncharged child abuse was improperly admitted, suggesting propensity and causing prejudice, similar to the issue in Prine. In Clairhout, the prior DUI evidence was admitted to show knowledge, not propensity, and was deemed non-prejudicial due to strong evidence of guilt. or relevancy. Let's see, appeal context. Hogan's appeal involves evidentiary disputes similar to those in Clarehout and Prine, where the court scrutinized whether prior acts were properly admitted. Gunby, this is a fun one. If you listen to almost any other Supreme Court hearing, they always come back to Gunby, especially as it relates to 6455. Sorry, I keep my throat's very dry and I keep backing up from the microphone. I'm sorry for the audio issues. Let's see. Appeal issues. Gunby appealed, raising 4 issues. Number 1, erroneous admission of prior violence evidence under KSA 6455. Whether jury instructions nullified the presumption of innocence. Let's see. State introduced testimony from Sharp's boyfriend, Nick Adriano, and friend Zoe Shamalin about a prior incident where Gunby allegedly put Sharp onto a bed, handcuffed her, choked her for 1 to 2 minutes. This was admitted to show Gunby's intent and absence of mistake or accident. Gunby argued that the evidence was improperly admitted to show propensity, i.e. that he was likely to commit violent acts. So when we start talking about a technicality, to me, this right here, Gunby, is a technicality. I know I didn't read the whole deal, but it's right up on the screen, right? On the day of the crime, Gunby, a high school student, skipped school with his classmate Amanda Ray Sharp and took her to his home in Johnson County, Kansas. They smoked marijuana and engaged in sexual activity. After an argument about their sexual encounter and Sharp's threat to have her boyfriend kill Gunby, he strangled her for about 10 minutes, resulting in her death. Gunby confessed to a friend, Brad Janes, and enlisted his help to move Sharp's body to his car trunk, planning to dump it. Janes reported the crime, leading to Gunby's arrest and discovery of Sharp's body. So the state admits this evidence, and they admitted their evidence to show Gunby's intent, which is the correct way to do it. Gunby argued that the evidence was improperly admitted to show propensity. He was incorrect. That's a technicality. This guy that's grasping at straws to me, right? He didn't do it right. He didn't appeal it correctly. And this is also the case where they eliminated the whole Ray Gesti thing as an independent basis for admitting prior bad acts evidence, requiring all such evidence to comply with KSA 6455's requirements. This ended the practice of admitting evidence as part of the complete story of the crime without statutory scrutiny. And the last one here, State v. Sieg, also referenced in the Hogan case. Let's see. June 2017, Leavenworth police stopped a truck Sieg was a passenger in, parked near a known drug house. After arresting Sieg on an outstanding warrant, police found an eyeglass case under the passenger seat containing a glass pipe, a silver spoon with methamphetamine, and 2 bags of methamphetamine. Sieg's DNA was on the pipe. Trial outcome. After a mistrial, a second jury convicted Sieg. He was sentenced to prison. Sieg argued that evidence of his prior behavior, i.e. associating with a known drug dealer, violated 455, which prohibits prior bad acts to show propensity. The court held the evidence was admissible as it was intertwined with the crime's events, such as being at a drug house, not as prior bad acts requiring a limiting instruction. So, I hope I've provided some sort of foundation here. I hope that I at least have somewhat adequately laid my foundation as to why I do not think that this was a technicality. And, all that said, I am interested as to what is going to happen with the Hogan case from here on out. I don't know how they recharge this with these new rules in place. They can't charge it the same way. So, I mean, in my opinion, just, if we're going to retry, put the old charges in there. Put the old charges in there for everybody. If, if a party is innocent, they should not be worried about a reinvestigation or a retrial. That's just my decision. Or I'm sorry, that is my opinion. So, in closing, if you made it to the end, from myself and from Kaleb's family, thank you so much for watching and sticking with us through this deep dive into Kaleb Hogan's appeal hearing. I encourage you to think critically and decide for yourselves. Is this overturned conviction just a legal technicality, or does it point to deeper flaws within the investigative and judicial process? While I personally believe that Kaleb is innocent, my opinion alone isn't enough, and it shouldn't be. All we're asking for is a fair and thorough investigation and trial for both of Malykai's parents, where the evidence speaks for itself. If someone is innocent, they should have no fear of letting the truth come to light. I'm not calling for harassment or any vigilante justice. I just want our judicial system to do its job properly, to seek justice rather than just a conviction, and to ensure the right person is held accountable. Thank you for joining us in this fight for fairness. Next up, we're going to be covering the 29-page document released by the same judges who overturned Kaleb's conviction. Stay tuned, and we'll keep you updated on what's next for justice for Malykai and Kaleb Hogan. Thank you for watching.